Welcome to the Deep Dive. Today we're tackling a topic that might sound a bit technical on the surface, WAF,
Right.
but stick with us because it unfolds into this really fascinating mix of history, community support, and actually some pretty intense legal battles happening right now.
Absolutely. Waqf is essentially this concept from Islamic tradition. Think of it like a perpetual gift, something intended to last forever.
A gift that keeps on giving, basically,
Hmm.
supporting things like mosques, schools, community services.
Exactly. For centuries, it's been a cornerstone of charitable endowment within Islam, deeply significant culturally and socially.
And our mission here is to unpack some major changes happening around WAF in India. We've looked into the new laws, the court cases.
Yeah, we're going to try and make sense of it, all the complexities, the key facts, and really guide you through what's a truly pivotal moment for this ancient system.
Pivotal really feels like the right word, because as we speak, things are actively unfolding, aren't they?
They really are. We're at this interesting point where the Supreme Court has just reserved its verdict, meaning they're deliberating right now on challenges to the big Waqf Amendment Act of 2025.
So the legal status is kind of hanging in the balance.
Precisely. And at the same time, just very recently, on July 3rd, 2025, the central government notified brand new rules.
Ah, the operational side of things.
Yes, the Unified Waqf Management, Empowerment, Efficiency, and Development Rules 2025. Quite a mouthful.
Yeah, fair.
But the aim is to completely overhaul how these vast Waqf properties are managed. So you've got this clash or maybe convergence of history, law, and modern governance playing out.
Okay, let's back up a little for anyone less familiar.
Yeah.
Can you define WACAV a bit more concretely? What is it at its core?
Sure. So Waqf is the permanent dedication of property. That could be land, could be buildings, could even be money.
Okay.
And it's dedicated for specific purposes, usually religious or charitable within the Islamic framework. The key idea is permanence. It's meant to benefit the community indefinitely.
And the person doing the dedicating.
They're known as the Waqif, and the act itself, often linked to the concept of Mushra al-Khidmat, really emphasizes this idea of service to the community through the endowment.
It sounds like a powerful concept.
Right.
And in India, it has a huge history, right? Not just a modern thing.
Oh, absolutely massive. It's been recognized under Muslim law for centuries and has been fundamental to building community infrastructure.
Right. I've even seen mentions, though maybe sometimes disputed, connecting places like the Taj Mahal historically to Waqf endowments.
Yes, those connections are sometimes debated, but it shows the scale and historical depth we're talking about. Waqf has funded countless schools, hospitals, mosques, public works across India for a very long time.
So what's the scale today? How big are we talking?
It's staggering, really. Current estimates put it at over 8.72 lakh. That's 872,000 Waqf properties,
Wow.
covering more than 38 lakh acres across the country. It's vast.
And who manages all this?
It's managed through a network of state Waqf boards, which operate under the oversight of the Central Waqf Council.
Okay, so a huge system, deeply historical, intended for charity,
Yeah.
but clearly something prompted these massive reforms we mentioned. What were the problems?
Well, despite the noble intent, the system has faced significant challenges over the years. A lot of potential revenue from these properties just wasn't being realized.
So, inefficiency.
Inefficiency, yes,
Yeah.
but also major issues with encroachment, people illegally occupying Waqf land. Poor maintenance was another big one.
And mismanagement.
Yes, unfortunately. There have been long-standing complaints about mismanagement and, in some cases, outright corruption.
Any specific examples that really brought this to a head?
The Karnataka Waqf Board land scam was probably one of the most high-profile. It highlighted just how extensive the problems could be and really fueled the calls for reform. It showed why change was needed.
Right. When you have that scale of property potentially being misused, it makes sense that there'd be pressure to act. Which brings us to the Waqf Amendment Act of 2025. You called it a radical overhaul.
It really was. The legislative journey itself was quite something. Introduced in August 2024, it went through intense debates, 12 hours in the Lok Sabha, 14 in the Rajya Sabha.
So not rushed through quietly.
No, definitely debated heavily. It passed on April 4th, 2025, and got presidential assent literally the next day, April 5th. That speed, post-debate, signaled a strong push.
And there was talk of renaming it.
Yes, to the UMED Act, Unified Waqf Management, Empowerment, Efficiency, and Development Act. That name itself kind of signals the broad top-down reform agenda.
Okay, so what are the core changes? What did this act actually do?
Several really key things. First, on the formation of Waqf itself. New rules are much stricter.
Oh, so?
Only a person practicing Islam for at least 5 years can now declare a waqf, and they absolutely must legally own the property.
That 5-year rule sounds specific.
It is, and it's
Yeah.
controversial. Also, crucially, the concept of waqf by user was removed.
What's waqf by use?
It was a historical principle where if a property was used by the community for religious or charitable purposes for a very long time, it could be recognized as waqf even without formal dedication paperwork.
So removing that could impact older, maybe less formally documented community sites.
Exactly. Big potential implications there. And another point on formation family waqfs, known as waqf al-awlad, now explicitly cannot be used to disinherit heirs, and specifically female heirs must be included.
Addressing potential inequalities there. Okay, what about managing existing properties, surveys, and oversight?
Big shift here. The power to conduct surveys of waqf properties moves from the specialized survey commissioner to the district collector.
So from a WAF-specific body to a general government administrative official.
Precisely. That means significantly more direct government oversight in identifying and managing these properties.
And what if government land was somehow declared WAF?
The act is very clear. Any government property declared waqf ceases to be waqf. The collector determines the rightful ownership and updates the records. Effectively, the government reclaims it.
Okay, quite a reversal power there. What about the boards themselves, the Central Council and state boards? Who sits on them now?
This is another huge area of change and contention. For the Central Waqf Council, the previous requirement that certain members like MPs, former judges, eminent persons had to be Muslim, that's gone.
Dying completely.
Removed. Now it actually mandates 2 non-Muslim members and allows for up to 12 out of the 22 members to be non-Muslim.
Wow, potentially a non-Muslim majority.
Potentially, yes. And similarly for the state waqf boards, state governments now nominate all members.
All of them nominated by the state.
Yes,
Okay.
and they can also be non-Muslim. The rules mandate 2 non-Muslim members, 1 member each from Shia, Sunni, and backward classes of Muslims, and importantly, 2 Muslim women members.
So a very different composition. Less internal community control, more state appointment and mandated diversity, including non-Muslims.
That's a fair summary. It fundamentally changes who governs these religious endowments.
And the legal side.
Yeah.
The tribunals that handle disputes.
Also changed. The requirement for an expert in Muslim law on the Waqf tribunals. Removed.
Really, no requirement for specific religious law expertise.
Nope. Now, a tribunal consists of a current or former district court judge as chairman and a current or former state government official of joint secretary rank. So it's framed within a more secular legal structure.
MPLs.
Previously, tribunal decisions were often final. Now, under the new appeals process, decisions can be appealed to the High Court within 90 days. Adds another layer of judicial review.
Okay, these are truly sweeping changes across the board. Formation, survey, management, governance, legal process. It's no wonder it sparked controversy.
Immediate and significant backlash, yes. Critics, including petitioners like Asaduddin Owaisi and Amanatullah Khan, jumped in quickly.
What was their main argument?
Primarily that the act violates the Constitution, specifically Article 26, Clauses B and D.
Which deals with?
The rights of religious denominations to manage their own religious affairs and own and administer property for religious and charitable purposes.
The freedom of religion and autonomy angle.
Exactly. They argued the 5-year Islam practice rule is discriminatory, removing waqf by user undermines historical endowments, and allowing non-Muslims on managing bodies infringes on the community's right to manage its own religious affairs.
Their core point being that waqf isn't just property management, it's integral to Islamic practice.
Precisely. Interwoven with religious life, they argue, and therefore constitutionally protected from this kind of state interference.
So this landed squarely in the Supreme Court's lap.
It did. The first hearing was pretty quick, April 16th, 2025. Chief Justice Sanjeev Khanna leading the bench.
And you mentioned many petitions.
Over 65 petitions challenging the act were filed. That number alone tells you the breadth of the opposition.
65. Okay, so in court, what were the key legal points argued by the petitioners?
They doubled down on the constitutional arguments. Does the 5-year rule violate religious freedom? Is excluding waqf by user discriminatory? And crucially, does putting non-Muslims on waqf bodies violate Article 26's guarantee of religious autonomy? They kept hammering the point. Waqf is integral to Islam.
And the government's response. How do they defend the act?
The government, through Solicitor General Tushar Mehta, focused on the need for transparency and better management, tackling those issues of corruption and inefficiency we talked about.
But legally, how did they counter the Article 26 argument?
Their key legal argument was that Waqf, while related to religion, is not an essential religious practice in the strict legal sense.
The essential religious practice test.
Exactly. Their stance is that if it's not essential in that specific constitutional way, it doesn't get the full protection of Article 25, freedom to practice religion, or Article 26, managing religious affairs. Therefore, the state can regulate it for better administration.
That's a critical legal distinction they're making. So how did the court handle this initially?
Well, they issued interim orders quite quickly on April 17th. These orders prevented the government from denotifying any existing WACs and stopped new appointments to the WACs boards under the new act.
So a pause button on some key operational parts while they considered the case.
Essentially, yes, a temporary freeze. And then, as we mentioned, fast forward to July 5th, 2025, and the court reserved its verdict, so now we wait.
The whole system's future kind of hanging on that decision. And this isn't just a Delhi issue, is it? There's a split across states.
Definitely. It highlights the political dimension, too. 6 states, Haryana, Maharashtra, Madhya Pradesh, Rajasthan, Chhattisgarh, and Assam have actually come out in support of the Amendment Act.
Interesting. So clear regional divisions and political alignment on this.
It underscores how polarized the issue is nationwide. Not everyone agrees with the challenges.
Okay, so while the Supreme Court deliberates on the act itself, the government rolled out those new rules. You mentioned the UMED rules, let's call them for short. Tell us about those.
Right. The Unified WAF Management, Empowerment, Efficiency, and Development Rules, 2025. Notified July 3rd, but made effective retroactively from April 8th, 2025.
So applying from shortly after the act was passed, what do these rules actually do on the ground?
They're very focused on operationalizing the Act's goals of efficiency and transparency. A huge piece is the centralized portal and database.
A national database for all WAC properties.
Exactly. Supervised by a joint secretary in the Ministry of Minority Affairs. Every property gets tracked, gets a unique ID automatically generated.
That sounds like it could genuinely tackle issues like encroachment or lost records.
That's definitely the hope. It makes oversight much easier. States need to appoint their own nodal officers and set up support units to feed into this national system.
Okay, a big push for digitization and centralization. What else?
Mutawali registration. The managers or mutawalis of individual WAC properties now have to register using their mobile number and email, verified by OTP.
Bringing individual managers into the formal system, making them accountable.
Right. Then there are stricter rules for audit and accounts. Clear guidelines on maintaining financial records, conducting regular audits, and importantly, publishing those audit reports publicly under Section 48 of the Act.
Public audit reports, that's a significant transparency measure.
Potentially unprecedented transparency for WAC finances, yes.
What about resolving disputes over whether something is WAC or not?
The rules set an inquiry timeline. If the district collector initiates an inquiry into whether a property was wrongly declared WAC, that inquiry must be completed within 1 year.
Speeding up potentially long drawn-out property disputes.
That's the aim. And finally, the rules reiterate the maintenance provisions, making it clear that income from WAC properties must be used to support vulnerable groups like widows, divorced women, and orphans, reinforcing the core charitable purpose.
So these rules seem very practical, focused on administrative fixes. But you mentioned attention earlier because they're based on the act that's currently being challenged.
Exactly. That's the tricky part. These rules are putting the amended act into practice, implementing its provisions, while the act's fundamental legality is still under review by the Supreme Court.
So the government is moving ahead with implementation.
While the foundation they're building on is being legally contested, it adds another layer of complexity and tension to the whole situation. The court's eventual verdict will obviously have huge implications for these rules, too.
Let's bring it back to the everyday impact. For the average person, maybe someone who benefits from a WAC-funded school or visits a mosque on WAC land, what does all this mean?
It's a double-edged sword, really. On the one hand, the promise of transparency is huge. That central portal, the audits, they could mean less corruption, less mismanagement.
Like preventing another Karnataka-style scam.
Potentially, yes. If properties are tracked better and finances are public, it empowers communities and oversight bodies to ensure the money goes where the Waqf intended to: schools, hospitals, community support. That's the positive potential.
Okay, that's the efficiency and transparency side. What's the other edge of the sword? The autonomy concerns.
That's the big worry for many. Will increased government control, especially with state-nominated boards that include non-Muslim members, dilute the specific religious character and purpose of Waqf?
The question being, can someone without that specific religious background or connection truly understand the nuances the community needs, the spirit behind the endowment?
Precisely. There's a real fear that this shift erodes the religious autonomy guaranteed by the Constitution, that it turns these unique, faith-based institutions into just another category of state-managed assets. That's the core tension: efficiency and transparency versus religious autonomy and community control.
It makes me think of, say, a historic family foundation. Bringing in outside managers might make it run more efficiently by some metrics, but could also change its original character or priorities in ways the founders never intended.
That's a very good analogy. Or like you said before, the neighborhood park example. New rules from an outside body might streamline things, but fundamentally alter how the community has used and valued that space for generations.
Especially when religion and deeply held community values are involved. Change is always complex, but here the stakes feel particularly high.
They absolutely do. You're dealing with centuries of tradition, vast assets, fundamental rights, and community identity all at once.
So wrapping this up, as of early July 2025, the Waqf system in India is undeniably at a major crossroads. We have these new rules pushing hard for centralized management and transparency.
While the Supreme Court holds the fate of the underlying law in its hands, reflecting these deep societal and legal divisions over how to balance tradition, religious freedom, and modern governance.
The outcome here could set a huge precedent, couldn't it?
Absolutely. Not just for Waqf, but potentially for how other religious or community-based endowments and trusts are managed in India, and maybe even how other diverse nations approach similar issues.
So here's a final thought for you, our listeners, to chew on. As we watch this shift towards digital tracking, centralized control, and redefined governance for these ancient charitable trusts, what does it tell us about the evolving dance between religious autonomy and state oversight in a country as diverse as India? And maybe, how might this precedent ripple outwards, shaping the future for other kinds of community assets?
Definitely something to keep an eye on. We'll certainly be watching for that Supreme Court verdict.